Support comes from Mosby Building Arts. Sometimes the smaller home projects make the biggest difference. Mosby creates custom spaces that help you love your home even more. For projects big and small, visit callmosby.com.
This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. Missouri's Attorney General has brought a legal challenge to Kansas City's contracting ordinances. Does it matter that the man she says is a victim of the city's program has mob ties? A new law seeks to crack down on anti-Semitic speech, but could it actually run afoul of First Amendment rights? And a St. Louis judge issued a warrant for the arrest of a perennial presidential candidate, only to quash it later that day. Did the judge go too far? Big questions for good lawyers, and we have three with us today. Yes, it's our Legal Roundtable, and today we're joined by one of its founders. Bill Freivogel is an attorney and a professor for the School of Journalism at Southern Illinois University, Carbondale. Bill, welcome back.
Hi.
And we're also joined today by Brenda Talent. She's a longtime attorney. She was previously a partner at the firm now known as Bryan Cave Leighton Paisner. Today, she is CEO of the Show Me Institute, which advocates for small government and market solutions for public policy in Missouri. Brenda, welcome back.
Thank you.
And last but never least, we are joined today by Javad Khazaeli. He's a former federal prosecutor and an attorney and founding member with the St. Louis firm Khazaeli Wirsch. Javad, welcome back.
Great to be back.
So, how much power do the people of Missouri have to push back on state lawmakers? Two ballot initiatives seeking placement on the November ballot are trying to force that question. And last week, Cole County Circuit Judge Daniel Green ruled on both. Now, the first initiative wants to let voters weigh in on the state's new congressional maps. These were pushed by President Trump. They were approved by the legislature. Democrats want voters to get a chance to overturn them. The second initiative seeks to limit the legislature's power to alter or repeal measures that have been passed by voters. This, too, is pushed by Democrats. They want to make sure that when, say, voters decide that abortion should be legal, the legislature doesn't immediately turn around and undo that. Well, in both cases, Judge Daniel Green said no. No to voters getting to weigh in on the maps, and no to this ballot initiative that would limit the legislature's ability to alter or repeal what the people have done. Now, in both cases, the Missouri Supreme Court has the ultimate say. But let's break down. What is Judge Green doing here? Are these rulings, they sort of walk step in step, or are there two different legal arguments, Bill?
Well, they're sort of lockstep, and they're lockstep with the Republican briefs in the case. I mean, I don't want to be too awfully critical of the Judge Green. He is, by the way, a Republican himself. But because everybody wanted him to decide both cases fast, because we're running out of time before the election.
And he decided fast.
And he decided fast. Rudy Keller, who is a veteran reporter for the Missouri Independent, described it this way. He said that Green adopted every argument and most of the language proposed by the three Republican interveners, striking a handful of paragraphs and making other minor edits before issuing the decision.
I guess if you're going to move fast,
like a cut and paste job.
Yeah, you got to rely on what's already there, right?
That's right. So, but it was good that he acted quickly, and you can make an argument. His main argument is the Missouri Constitution says it's the legislature's job to redistrict, and the Elections Clause of the U.S. Constitution says state legislatures are responsible for the times, places, and manner of elections to Congress. So these two explicit references to elections is a reason that the legislature should have the power to do it and not some sort of not be subject to a referendum. He's got a few problems though, because Article 3, Section 49 of the referendum provision says that people can vote on any act of the General Assembly. So he had to find a way to say that any wasn't any, which he found.
But any does not include maps.
The other problem was that referendum provision also has it delineates the exceptions that cannot where the people cannot have a referendum, except as to laws necessary for immediate preservation of public peace, health, and safety, laws making appropriations for current expenses of state government, maintenance of state institutions, and support of public schools. Nothing in there about elections. And those are the specific exceptions.
So when I hear Bill sort of analyze this, I'm thinking, okay, this is the circuit court decision. The Missouri Supreme Court might take a much different view. Brenda, do you think that's possible?
It's possible. Look, I come at a different angle for these cases. I haven't been tracking them that carefully, so I read the decision. I think that, whenever you're talking about interpretive rules, which is what we're talking about when we're looking at the Constitution, you can say the plain language provides. Personally, I can see the argument that you want to interpret the Constitution consistent with the intent of the writers. And we do have a situation where there was a challenge way back when there was a referendum on, I think it was a senatorial redistricting. Then we had the 1945 Constitutional Convention, where both for the House and Senate redistricting for the state, there's specific references. Can't do a referendum here. And I don't think it's that far of a stretch to make an interpretation that says in these two areas where we're talking about redistricting, we're not going to have a referendum. I also think that when you look at the practical limitations of referendum, which I really think are highlighted more in the second case, but in this one too, just think about redistricting and asking voters. Now, you can say, well, asking the voters yay or nay on a redistricting is an easy question. But if you're actually asking them about what should the boundaries be?
Oh, it's like, can I please delegate this to an expert?
But it's not only that. You've got limitations, 100-word description, those types of things. So yeah. I could see this case going either way. And as I say, I think you, as a court, can pull out any interpretive rule you want to try to make the persuasive argument that I'm reading it the correct way and you're not.
Well, I would agree with Brenda that it could go either way. Of course, the spot that we're in is due to the Secretary of State, who
he did not move quickly.
Very specifically put us in this spot, and then congratulated himself, calling himself the Sultan of SWAT, just like Babe Ruth, winning the big ones in the local court. I mean, really.
The higher court battle looms. You want to remind him of that. Javad, I see you wanting to hop in
I think that's actually a really important point, because the Republican argument was they made the language argument. But one of the arguments that they made was this will cause chaos if we do this late. The other argument was it doesn't matter if it causes chaos. It's what is the law. But when you look at what would cause chaos, it's exactly what Bill just said. The Secretary of State had this, could have made this decision 6 months ago, waited until the absolute last day to make this decision, and then everybody throws up their hands and says, there's just not enough time. I mean, what I'm really afraid of is there are certain things that Americans all agree on. Gerrymandering as a whole is something that Americans believe is not democratic, is not what America stands for. This is a step to say that if a vote comes up to say in Missouri, we as the people don't want gerrymandering. We want this to be done fairly, that somebody can say, no, there are congressional people say they don't want that. And the argument that Congress, or actually our state reps, are able to make decisions and they're not controlled by the Constitution, which, as Bill said, says we can vote on anything and limit them in any way except for these 2 or 3 things, basically means that they're not accountable to anybody.
Well, that's not correct. You can vote them out of office. You can have recall petitions. I mean, there's so many ways to hold them accountable.
A single person out of office.
It's always the problem is it's sort of like, I don't like what you're doing, but I like what my guy's doing. And I think, when we talk about redistricting, it is inherently a political process. It doesn't have to be a partisan one. It often is on both sides of the aisle. Look at what Virginia did. So, it's just it's part of the political process.
But that's why having a vote where every single person in the state can vote on this and their votes count the same amount It's not a political answer when in the end, more than 50% of people agree on this. When people talk about abortion in this state, people say it's political. We're in a red state that votes for Donald Trump. But our people voted more than 50% for a woman's right to choose.
I think one of the things we have to ask ourselves in this whole initiative petition process is, are we asking simple questions? So like that question can be simple, but it can be complicated. And it can be complicated because you could draft something that says, do you support a woman's right to choose? Okay, life of the mother, incest, rape, any circumstance whatsoever. I don't get to make those different choices on these initiative petitions. I just have to check yes or no, and it may encompass all those things, whereas I would want to carve out certain things. I think when you look at the initiative process, it functions best when you're giving a very simple question that is subject to yes or no. And this is the whole debate between, direct governance versus our republic. Small r, right? Republican style of government. And that's part of the process when you put these very complex and technical issues before voters, it doesn't really work well.
But you can't really say abortion is so complicated and technical, we can't let the voters
No, I didn't say that. But what I have my opposition to is, and it's highlighted in the second one where he said, there's not a single subject there. It's ironic to me that we're having an initiative position which is saying we want to protect the sovereignty of voters, and it's undermining the sovereignty of voters.
So I want to jump in here because it feels like we're sliding into some political arguments when public radio does a great job of covering political arguments, and we are here to talk about the law, which they are so intermeshed. But that is no disrespect to any of our discussion here today.
But part of the initiative process is, in fact, we have all this case law on what is single subject. And I couldn't articulate whether you violate single subject or not. It depends upon how the court feels often.
Right. It's what often we learn on the show. Lawyers gonna lawyer, and the court will ultimately rule.
It actually says single article, not single subject.
I would just point out that if the end argument is we've made the system too complicated for voters to be able to vote on anything, thus we should strip the voters of the ability to vote on things. That's not democracy.
Well, so I'm gonna retake control of this conversation. I don't know if I have to cut mics to do it. No, I want to bring this back to one legal question, which is ballots have to be printed beginning September 9th, September 8th is the deadline to get stuff. Bill, you started by praising this judge on one point, which was that he moved quickly. Do you think this case can possibly wrap up in time? There's still more steps on this.
Well, I guess the arguments are next week. I suppose the Missouri Supreme Court will act quickly.
You think they can spit out a decision the same day? I see Brenda nodding.
Too. No.
Yeah. But you think we will get a decision in time for this ballot? They are not going to sit on this.
I think it's possible. It's really hard. It's a tough deadline.
I think if the decision is going to be that, in fact, it needs to go forward, we're going to see a very quick decision. If they think it doesn't need to go forward, they could take more time.
That's a good point. We could read into it just based on how long it's taking.
Could I make a big picture point that's a legal point?
As long as it's a legal point, Bill.
It is a legal point. And I want to blame the Supreme Court for sort of messing up our election system in a lot of ways. 10 years ago, the Supreme Court was on the verge of outlawing partisan gerrymandering, and they were one vote short. 16 years ago, they, by one vote, gave us Citizens United. And over the last 20 years, they have demolished the Voting Rights Act. These three things have made our elections more partisan, our districts more red or blue, and I think it really hurt our democratic system.
I'm going to let Bill Freivogel have the last word on that, as much as I suspect Brenda wants to jump in. We're talking today to our Legal Roundtable. That is Bill Freivogel. We're also joined by Brenda Talent and Javad Khazaeli. We need to take a quick break. When we come back, we'll talk about Catherine Hanaway's challenge to Kansas City's construction equality program. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from Gemma, architects, planners, and designers seeking to bring joy to their clients and communities. Details at gemastl.com.
Welcome back. I'm Sarah Fensky. I'm in for Elaine Cha because today is our Legal Roundtable. We convene 3 top lawyers from around the region, talk about what we're seeing happening in our local and state courts. And from there, we can often learn a lot about the law. Today, we're joined by 3 really good lawyers. That includes Javad Khazaeli, who's with the St. Louis firm Khazaeli Wersch. We're also joined by Bill Freivogel, who's an attorney and a professor for the School of Journalism at Southern Illinois University, Carbondale, and Brenda Talent, who's a longtime attorney, also CEO of the Show Me Institute. They advocate for small government and market solutions in Missouri. So, Brenda, I want to start with you on this. Attorney General Catherine Hanaway is seeking to challenge Kansas City's construction equality program. She says the city is biased against men and white people. Well, the Kansas City Star had the kind of like juicy detail that I, as a former tabloid journalist, it set my heart aflutter. The person she's filed this suit on behalf of, the named plaintiff, is somebody who has mob ties. He was actually prosecuted in 2003 by the Department of Justice. This was a unit that was tasked with disrupting and dismantling the Mafia, the Irish mob, the Russian Mafia, and other gangs. In the role that he's playing in this lawsuit, does that matter?
The technical answer is no.
And that might surprise people. Like, she's bringing it on his behalf.
Well, and let's be fair to him. Do we ever forgive anyone? It's 20 years ago. Do
it
you
was
ever
20
break your
years ago.
ties?
That's journalists don't forgive.
This lawsuit, she could have just brought in her own name. She didn't have to bring a plaintiff. I suspect, and I don't know, you want to vet your plaintiffs because you don't want stories like this, right, in the headlines. You don't want that to distract from the arguments you're making. But I suspect, and there are a lot of different ways you could look at it, so I'm just guessing that she chose him because he's had existing contracts with the city.
He owns like a wrecking company.
Right. So to show that he is acceptable to the city, but that he can't participate in these programs because he's a white male. And so that, I assume that, but I don't know if that's the logic or not, because again, she could have just brought this lawsuit on her own without bringing another plaintiff.
Javad, I sometimes see you have cases with like a named plaintiff. Would you have gone forward with this one, or would you have just brought it yourself if you're Catherine Hanaway?
I mean, I have this thing called Google, and I type into Google and other things questions about my clients. And when I find articles about my clients being involved in the Mafia, and there's many of them, I tend to tell them that they don't have very good cases. It doesn't happen often, but every time it has, I have said, no, I can find somebody better. Here's my issue with this. Is this a good case? Maybe. I think that we have to be clear about the seismic shift that has happened in America. I do civil rights and I do immigration. There are hundreds of thousands of people in this world who need protection in America. Other than 2 people, every single refugee we've brought into America has been a white person from South Africa in the last year. This idea that the main force that the government needs to be putting its attention towards is protecting white men seems to me like there are probably other things that we should be focusing on. And the idea that these are the things in Missouri that our attorney general is focusing on, using terms that she likes to use, this strikes me as a virtue signaling to the President of the United States, that the things that we really care about, of all of the things that we have to worry about in Missouri, we just got to make sure that white men finally get their fair shake in this country because it's just been really tough for them, especially the Mafia ones.
I think that we are, sort of throwing by the wayside the concept that our government is not supposed to discriminate unless they've got a compelling interest. And Kansas City commissioned their own study. That study came back and said, while you may have had a compelling interest many years ago to rectify this systematic discrimination, there's no evidence, statistical evidence that exists anymore. And by the way, you can address this now by simply having set-asides basically for small businesses, which may inadvertently benefit minority-owned or women-owned businesses, but that is neutral. It is racially neutral. It's gender neutral. That's allowed under our Constitution. And I don't think we should just say, oh, this is to benefit white male. I mean, we've seen Asians discriminated against on these kinds of,
It's been a huge thing in college admissions.
It absolutely has. So I think we need to look and say our government, if our government is not going to be blind to color or gender, then they've got to have a compelling interest to make those distinctions.
Bill, do you think Kansas City could advance some sort of program where they could try to give minorities and women a leg up? Or is this something where they have to come up with something like, we're just going to have small businesses do it race neutral with the current Supreme Court landscape that we have?
Well, I think that they can come up with a program that could be aimed at bringing all sorts of people, women, minorities, and white contractors who might be in small firms for close consideration. Brenda's stating the law right. There has to be a compelling government interest. There was a compelling government interest in the days when the trades were almost all white.
Back when the mob was running the trades. No.
But that's actually a good point, though. The question is, why does this guy have this long history of being able to get these contracts? I don't know. Maybe it has to do with the fact that he had mob connections and that those types of advantages that he had over the last few decades. That's why he's just a terrible plaintiff on this one. I mean, I think Brenda's right on this. You could have found a much better plaintiff on this.
Yeah.
Well, recognize some of the allegations against him was basically bribing government officials. So
Right.
Maybe
that helps you get contracts.
Yeah, that does feel like that could get your foot in the door.
It's a little bit of, I tend to have a lot of nerve, but for me to say, I bribed a bunch of government contractors and now you're not giving me, contracts now and you're giving it to black people instead of me, that's unfair. Well, they might not have had the money to bribe government contractors for years.
Yeah, as you say, that is a lot of nerve. There's something else that caught my eye about this. So Catherine Hanaway brought this lawsuit, and pretty quickly Kansas City decided they are going to drop this program. I think they saw the writing on the wall. But she said she's going to continue with this lawsuit. Brenda, I know you've done some things law in the public interest. What can she just do that if there's no longer a program to inveigh against?
I would assume that the city is going to try to argue the lawsuit's moot. But she might be trying to get an injunction to prohibit them from reinstating anything similar in the future. I don't know how the court would consider that because they are proposing ordinances. I didn't dig into the ordinances completely. I've seen some criticisms of what they're drafting. They certainly did seem to drag their feet because 2 months have passed since they heard. I mean, they're the contractor that they hired say, this is illegal. It doesn't fly. And only now are they beginning, after the lawsuit was filed, to file these ordinances, which look like they're not quite ready for prime time.
Oh, okay. Some of these draft ordinances you're saying they feel a little rushed.
That's the only thing I can suspect of why she's continuing it, because she's trying to get an injunction.
Bill, does that make sense to you, too?
Yeah, that could be true. Yeah, if something is capable of happening again, that's when a court might be willing even to dismiss a claim of mootness.
So I want to transition to a different case here, but this also involves issues of race. A black Brentwood police officer is suing that city. She says a coworker's harassment crossed the line, that she endured racist and sexist harassment. Her coworker said, this is according to her lawsuit, that she should get 3/5 of a vote. He called her a diversity hire. He set up a fake Facebook account so that he could accuse her of drug abuse and instability. I'm thinking, this is like the coworker from hell. She's suing not just him, but the city. She accuses the city of failing to investigate her complaints and then retaliating against her for making them. Javad, assuming her allegations are true, is Brentwood and its police department in trouble here?
Yeah, like really bad. One of the things that we need to just acknowledge is that racism has always been cloaked in humor. People don't come right out and say the N-word. They use racist jokes like this. And for generations, we've been stamping this out. We've been telling people that this is unacceptable. And one of the first places that we laid down the law on this was the workplace. Women shouldn't be treated this way. Minorities shouldn't be treated this way. People with disabilities shouldn't be treated this way. But this is when we can draw a line. When our government now has said that the thing that is most important to us is protecting, and I understand what Brenda said earlier, but the language that Catherine Hanaway used was this is discriminatory versus white men. When we shut down refugee programs and we're only bringing white people in, when we start using the term DEI as a slur, it shouldn't shock anybody that those gates are being reopened. And now people feel more comfortable saying these things. Now people think that it's okay to say these things. Because what I would expect is, why isn't the Attorney General's office looking at this police department to see why you're treating this black officer this way? Instead, they're worried about protecting the Mafia guy over here. And all of these things have a direct line to each other. He used the specific term, you are a DEI hire, okay? DEI was a good thing until the president decided DEI was a bad thing. This gate is open because of these actions we're taking with the law.
So looking specifically at this woman's case, she's not just suing this coworker. She's also suing the police department. Did they need to take action here?
Well, yeah, the supervisors told her to get a thicker skin. It was investigated as an internal affairs rather than a human rights violation. And the lieutenant and the captain who did that investigating said, no problem here. And yeah.
Which seems crazy. I think to anybody reading this lawsuit, I'm thinking I can't think of a single workplace where something like this would fly, much less one that's funded by the taxpayers.
I think the supervisor said horseplay.
Well, it's amazing to me because when I did read it, I had exactly the same reaction to this. It's sort of like they all need to go back for training on what constitutes hostile work environment, harassment, discrimination. I mean, this is 101. I really was like, I cannot believe this got through and nobody did anything. It's outrageous.
So I get that, except for I spend my days looking at police IAD records. I have cases like the Bar PM case where that officer beat up somebody. When we look at the file, we see dozens upon dozens of times of him beating people, and each time it's not sustained.
I would think that Javad was exaggerating, except my news outlet has, dug into these records, and he's actually telling the truth in this case.
When you allow groups to self-investigate, when there's no accountability, things like this happen. The person, and let's be clear, the person who made these comments wasn't just a random officer. According to the article, it was a corporal. This is a senior manager in the department. This is somebody who I guarantee you this isn't the first time they did this. And I guarantee you if they're treating a black employee in their office who has union protections this way, my guess is that black kid who's walking through the Galleria in Brentwood who has a run-in with this person is still going to have a problem. So I agree that there should be retraining, but the retraining is not going to be done by another officer.
There should be consequences.
For sure.
Yeah. But Javad, say you're representing somebody who's gone through the Galleria and they end up getting roughed up. Do you think you could bring in things from this lawsuit now as evidence? This opens the door.
Well, as long as I have a good faith argument to say that the interaction was race-based, absolutely this will happen. I mean, I'll give you another example. We just won a trial earlier this year, $37 million, where a jury found that a St. Louis police officer shot an unarmed black kid who was 14 years old and planted a weapon on him. That officer's still on the streets. That officer has not been disciplined in any way. This idea that police departments now can self-regulate, they need to be disciplined. But the reality is that the way that these guys are only held accountable often, their departments don't do it, is when people come out and sue them and make them write big checks. And then hopefully their taxpayers will say, too much.
But you're saying in this case that hasn't even happened. Somebody's supposed to write you a $37 million check. This guy's still on the force.
He's still on the force. Luckily for me, the taxpayers are paying 10% interest on that every single day. So
you got to remind me of this. As a city resident, I do not enjoy that little statistic. Bill?
My kids have to go to college.
The backlash, there were some reforms after George Floyd was murdered. And the backlash to those reforms has been very substantial, and we have it right in the state of Missouri and a lot of other states. Law Enforcement Bill of Rights. I mean, it keeps names of these officers, secret, and keeps citizen review boards from being able to operate. It's really too bad that police accountability after George Floyd really ended up being much smaller.
In a worse place.
I mean, Bill makes actually a good point that I didn't even think about until this moment. We had a civilian oversight board in St. Louis that was supposed to investigate officers like this from the outside. When the state took it over, they shut it down.
I think it's baked into the state law. They're not allowed to have it.
Yes.
Yeah. That, as you say, a backlash here. Bill, I want to talk to you about a different matter that to me also feels kind of like it's a backlash situation. This fall, state officials in Missouri schools and colleges are required to report speech and conduct that's critical of Israel if it's considered anti-Semitic. The report to state education officials could lead to discipline or other punishment. This is part of a new state law that mimics those in 18 other states around the U.S. Bill, you had some reporting on this in the Gateway Journalism Review, that this triggers some First Amendment concerns. What are the concerns here?
I think it does. The law says criticism of Israel that's similar to criticism toward any other country shall not be construed as being anti-Semitic. But
okay, so that sounds good,
so that sounds
right?
fine,
you can
right.
criticize them just like you'd criticize Canada.
Right. But then Aisha Sultan of the Post-Dispatch, who's done some really good work on this, asked the sponsor, Representative Ruza, is that how you say his? Yeah, say his name, whether or not calling Israel's actions in Gaza genocide, as a lot of organizations and human rights groups have done, would be considered to be against this law. And he responded, calling Israel's actions in Gaza genocide does not comport with the situation on the ground, or it is some kind of twisted definition of genocide. No other country would be accused of genocide for fighting a defensive war after an unprovoked attack and bending over backward to minimize civilian casualties. Only Israel. So yes, in other words.
Well, so what I'm hearing is I hear a lot of state representatives that I don't necessarily think of as the sharpest pencil in the box. And I guess I wonder, does that matter if there's a state representative who's sponsored a bill and he doesn't really even understand the letter of his own bill? Do his intentions matter when it comes down to how this thing plays out?
Well, you can read the statute. I actually am troubled by the same section you just mentioned because what it envisions, look, saying that you have to protect your Jewish students as well as any other student because of their religion or race, or that's perfectly permissible. There's language here that's also permissible about whether you're feeling like you're physically intimidated or that you're basically being harassed. So, that all of that kind of language fits within language we already have. In fact, we just talked about that language in that other case. But this particular section of it troubles me because you're right. When you read it, my concern is, they have language there that says, don't violate the First Amendment. Anything in here, they try to limit it. But the problem is you're having this law, it's going to be interpreted by these educational institutions. And my concern is that these institutions are going to develop codes of conduct that go too far, that in fact do violate First Amendment, and it's vague enough that it's sort of like, well, wait a minute, is this prohibited? Can I say it? So the Bill's example, absolutely you can say that. That's protected. And you know what? You can come from a place of ignorance. That is, you're right, under the First Amendment.
Americans are allowed to be stupid.
Or ignorant or whatever, right? Or have bad opinions. You can say that, but it doesn't fit within what you would typically think of as a hostile environment or harassment.
So I'm thinking, hey, this state legislator doesn't seem too bright. You're saying some of these administrators might not be any brighter. Is that kind of your concern of where this could go? Not to put too fine a point on it.
We've seen what's happened in educational institutions in the past.
Well, I don't think it's a brightness question. I think it's a fear question. With this law, you could come up with absurd outcomes where a Jewish student who criticizes Israel could be deemed anti-Semitic, and then their university could possibly lose funding over this. So if I'm an administrator and I say, look, I have a group of kids who are students for Palestine, all right, I'm not going to let them talk. Why? Because I've got a $20 billion grant coming through on the Human Genome Project, and if I smash these kids down, I might not lose that money for the grant. That's exactly what the whole point of this. This is to chill speech. I understand we're on NPR and we're trying to do, and talk on both sides. This is clearly, totally violates the First Amendment. I don't think that this is a close call at all. When you say that there's a specific one country that we have to protect, and if you say anything about it, that with this type of vague language, the question is, does it chill speech? The point of this is to chill speech. The point of this is to hold academia in fear so that a point of view that people don't want to hear isn't espoused.
I want to make clear that, I think that the October 7 Hamas attack on Israel was a terrorist attack and horrible. And I think also that at some universities, Harvard among them, in the wake of that attack, a lot of university organizations blamed Israel for having set up the situation that would lead to the October 7 attack, and that was ridiculous. And as a result, some Jewish students on those campuses, I think, were in situations where they didn't feel entirely safe. So I'm sympathetic with I do think that there should be protection of Jewish students from that kind of a situation, but there can't be a Palestinian exception to the First Amendment. Greg Majarian, who's been on this program, says that he thinks we're moving towards that kind of an exception for speech that is, supportive of.
And it sounds like if someone got in trouble over this law, they might have a really good First Amendment defense. But going back to what Javad was saying, nobody wants to be the test case on this and lose their funding as they slowly, painstakingly make their way up to the Supreme Court.
One interesting thing I came across, which I was surprised about, was that the local ACLU, they opposed this bill a year ago. This year, no. I contacted them 6 times to ask them why, and no response. The national ACLU opposed it, but not the ACLU of Missouri.
I do think that this is a reaction to what we've been seeing around the country. I think the Anti-Defamation League has reported like over 10,000 incidences of what they would consider to be anti-Semitic actions. We've had thousands of bomb threats against various Jewish institutions. But having said that, there are aspects of this where you can be clear that, being anti-Semitic is no different than being racially biased, but you can't go too far. And some of the language here does go too far. And by the way, I do believe, and you can correct me, Bill, or if you do have a lawsuit on this, you can get some kind of extra damages, right?
Yeah,
because it's a state law violating your First Amendment rights.
Yeah, under 42 U.S.C. 1985, you can get attorney's fees on these. At the same time, with everything going on, you have to find people who have the resources, the time, the ability to do this. These cases take years to do. The Eighth Circuit has had some pretty tough cases recently on the First Amendment, one that we lost. Putting people on the defensive and telling them that they're going to have to be the ones to protect this when this is the type of stuff that the government thinks is important, is very problematic.
We're talking today to our legal roundtable. That is Javad Khazaeli. We're also joined by Brenda Talent and Bill Freivogel. Coming up next, a St. Louis judge gets fed up. This is St. Louis on the Air on St. Louis Public Radio.
If you have a smart speaker, you have access to the entire world of NPR and St. Louis Public Radio. All the latest news and all the captivating stories. Activate our voices with yours by telling your smart speaker to play St. Louis Public Radio.
Welcome back. I'm Sarah Fensky. I'm here with our legal roundtable, three top legal talents willing to share their knowledge with us. I always learn so much talking to these guys. Today we have a great panel that includes Brenda Talent, who's an attorney and CEO of the Show Me Institute here in Missouri. Also joined by Bill Freivogel, an attorney and professor for the School of Journalism at Southern Illinois University Carbondale, and Javad Khazaeli, who is a founding member of the St. Louis firm Khazaeli Wersch. So Javad, I want to talk to you because you're a lawyer who's frequently in court. Every now and then you might rub a judge the wrong way, even though I know they all love you. You always tell me that, how
Most love him.
most love him. Let's not have the judges light up our phone lines telling us how annoying they find Javad. But here's a case that got a lot of attention. I would say it got international attention. A St. Louis judge last week issued a warrant for Jill Stein's arrest. Yes, the Jill Stein, a frequent presidential candidate for the Green Party. She was supposed to be in court in person on August 17th. She's been charged with a misdemeanor related to a protest at WashU where a whole bunch of people got arrested. Well, you know, this thing said be there in person, lawyer and defendant. Neither she nor her counsel appeared. So Judge Karma Johnson, she issued a warrant for Jill Stein's arrest. And the prosecutor said, we're not asking for this. It didn't seem to matter. Javad, do you think that was an overreaction or was that justifiable?
Well, so first of all, this happens all the time. The only reason this is a story at all is because it's Jill Stein. This is a misdemeanor. With misdemeanors, the defendant virtually never has to show up. The attorney has to show up. Sometimes there are miscommunications, and judges like to let attorneys know that they're unhappy and they do things. And this judge issued a warrant. Now, it would have been an overreaction if later in the day when the attorney showed up and said, oh my God, this is my fault and not Jill Stein's fault. Please, 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 please pull back the warrant if the judge hadn't, but she did. So this happens all the time. You know, sometimes I don't know why the attorney wasn't there. Sometimes we're triple booked. I've done things where I put things on my calendar when I'm in New York City and it puts it on Eastern time and I show up and the judge is done. It's embarrassing. It's awful. Not a big deal. This was resolved that day. It's not a story if it wasn't Jill Stein.
Do you think, the docket said the defendant and the lawyer should be there? If just the lawyer had showed up and he said, Your Honor, I'm so sorry. My client doesn't even live in the state of Missouri, but I'm here. Do you think there still would have been that warrant?
I don't even think that would have even been a question. We show up on misdemeanors all the time without our client. So I think if this was a status conference, this was probably talking about discovery or something. The client doesn't even need to be there. They need to be there to plea at the beginning. They need to be there to plea at the end. If it's a felony, that's different because it's much more serious. The courts often want to see you've got conditions on your release. They want to make sure that you're obeying. But on a misdemeanor, virtually never does anybody care about that. But if nobody shows up, someone's going to be unhappy.
That makes sense. Judge Karma Johnson, she's very new. I think she became a judge earlier this year. I wonder if she feels like, I've got to exert my authority. I need to show these lawyers that when, I'm not going to be one of these pushovers. Bill, what do you think?
Well, that might be. But I think one thing that's interesting about these cases related to these WashU protests where people were arrested is this whole argument that Brendan Roediger has been making about how the police officers hired by Washington University are actually not police officers, and so the charges against people for assaulting a police officer have to be dropped. And
There can't be a special victim if there is not actually a police officer. What I love about Brendan's case here is he found WashU itself argued they weren't police officers, and they argued that recently. Like, that just felt like, wow, this is some smart lawyering here.
Yeah, when one of these officers sued and said they didn't get due process and how they were fired, WashU said, "Well, you don't get due process because you're not we're a private institution. You don't get these protections." And also in FOIA, sunshine law cases, they say, no, we can't give you those documents
because these are not actually law enforcement officers. Do you think the reason the prosecutors dropped those charges against Brendan's client is because WashU did not want to continue to, they didn't want to get a final ruling saying, yep, you're right, these guys aren't law enforcement officers, have that precedent? I
don't know. I guess that's possible, or maybe the prosecutors just thought they didn't have much at that point.
Yeah, Brenda, any thoughts on this one?
Well, the only thing I'd ask is that even if they're not law enforcement, there is a misdemeanor assault. You could be charged on that just by doing it to another person. So there's still that offense out there. Yeah,
and I haven't seen them rebring this case. So hopefully we're not stirring things up by talking about it here today. Brendan will not be happy with me. We've got our final, 3 minutes or so here today. A Wentzville municipal judge facing removal from office says he's already suffered enough. Judge Michael Carter owned 5 Facebook pages. He also hosted this show on KMOV and ABC 30 called Justice and Journalism with Mike Carter. According to the Disciplinary Council in Missouri, he mocked defendants' physical appearances. He hosted public polls about pending court cases. He shared his opinions on politics. Now he's facing some disciplinary action, possibly removal. He says, I should just get censure. That's bad enough. Honestly, Javad, I feel like most of us reading this are like, how did he get away with this for so long?
I love this story so much. When I talk to my 10-year-old and I ask her what she wants to be when she grows up, she says, I want to be an internet influencer. And it's pretty clear that this municipal judge wanted the same thing.
Even though he was already a judge, which feels like a great job.
Not to denigrate any profession. He's a municipal judge. Right? But this is important, though. So municipal judges do traffic cases and things that don't appear in the normal circuit court system. We have a very bizarre system in Missouri. We have exempted our municipal judges from a lot of ethics rules. When you have a normal judge who's been appointed by the governor, they know they can't show up at a political rally. They know they can't endorse somebody. They know that they can't be a private attorney someplace getting paid by money. We allow people in Missouri to be a prosecutor one day in one city, a judge the next day in another city, a defense attorney in another city. We've got cases where there are people who are the prosecutors in 5 different cities, the judge in 2 cities, the city attorney, all that conflict. And we've told them the conflict rules and the ethic rules don't apply to you.
Because you're just a municipal court judge.
You're just a municipal judge. My guess is this guy thought, just a municipal court judge, I can do anything. But my favorite part of the story is even though he got 161,000 followers, he was told by the disciplinary committee, stop it. And he said, I promise I'm going to stop it. And he totally stopped it for 2 months. And then he did it again. Addiction. And now he's just sitting there going, I didn't know. I didn't know I wasn't supposed to call people in front of my courtroom fat. How was I? It's very Seinfeld-esque when you've got George saying, how was I supposed to know I wasn't supposed to sleep with the woman who cleans our office? I'm just ignorant of this. It's laughable and it's hilarious. And the fact that it's this guy and the judge who dressed like Elvis, I love it.
Brenda, in her final 30 seconds here, he's saying, how was I supposed to know? Do you think that's going to go over well with the Missouri Supreme Court?
I would hope not. He was told, he then delegated his Facebook. I mean, he gave authority supposedly over other people, and he got distracted, so he didn't monitor it.
You don't think that defense is going to play?
No, and I also question the believability of that, too.
And do you think this is going to maybe put municipal judges on notice? They got to act differently.
One would hope so, because they do wear the mantle of judge, so they should follow the rules. They should be held to the same accountability as other members of their profession.
Brenda Talent of the Show Me Institute, thank you for joining us today.
Thank you.
And Javad Khazaeli of Khazaeli Wersch, thank you.
Thanks for having me.
And Bill Freivogel of the School of Journalism at Southern Illinois University, Carbondale, thank you.
Thanks.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
Hi, I'm Laura Hamden, and my colleague Jessica Rogan and I are your daily hosts of the Gateway newsletter. We meet with the editors in the STLPR newsroom every weekday to bring you the top local stories of the day in a quick and easy 6-minute read by 6 a.m. In an age of overwhelm, it's a refreshing, thoughtful take on the news day, if we do say so ourselves. Fine-tune your daily news habit with the Gateway newsletter. Subscribe at stlpr.org/gateway.